Welcome to Building the Future. I'm your host, Kevin Horick. You can check out new episodes of the show every Tuesday and Thursday at 2 p.m. If you missed an episode or want to get more information about the show, please visit buildingthefutureshow.com. Season 1 of the TV version of Building the Future is now streaming online at buildingthefutureshow.com. Welcome back to the show. Today we have a couple of the team members from Christopher and Weisberg, attorneys at law. Ladies, welcome to the show.
Thanks for being on the show. I really appreciate you taking the time out of your busy day to be on the show with me today.
Oh, you're welcome. Thank you so much for having us.
Yeah, so maybe before we kind of get into exactly what you guys do, let's get to know each one of you a little bit better and maybe start off with maybe giving a little bit of a quick intro and kind of a quick bio, and then we'll go from there. Sound good?
Sounds great. Sure. My name's Catherine Koenig, and you'll meet Alyssa here in a minute. We both work for Christopher and Weisberg, an IP boutique here in Fort Lauderdale. My background was actually in plant sciences. I went to the University of Florida for a really long time and did an undergrad in horticulture with a minor of plant molecular biology, and then I went on to grad school there and basically did crop production, a doctorate program that University of Florida had just started to offer at the time. And it was a land grant school, and I loved the agriculture college and loved the science and thought that was what I was going to do. And then by some strange twist of fate, I applied to law school, and somebody suggested patent law to me because you have to have a requisite amount of science background in order to become a patent attorney. You have to sit for a separate exam with the patent office.
Oh, I didn't know that. That's interesting.
Yeah, it's also a pain in the butt too. It's no joke. But yeah, that's why there are relatively few of us, because in addition to having to suffer through law school, you also have to have suffered through a lot of science coursework. And I discovered I loved it. So here I am, and I do some plant patent work for some clients, and then the majority of what I do now is medical device work, which I also love. But again, I never thought I'd end up here, and I'm so glad I did. Very good example of following the road that you're given and not making concrete plans.
That's awesome. Alyssa, do you want to maybe give a quick background on yourself?
Sure. My name's Alyssa Tisdall, and I went to college and focused in biology and chemistry, and then after that went to law school. Following law school, I started practicing in Chicago, Illinois, and was doing general litigation, also a little intellectual property as well as business work. And I practiced there for a number of years. After I practiced in Chicago, I then took another bar exam after Illinois in the state of Maine, and I practiced in the state of Maine doing litigation and intellectual property as well for a number of years. After practicing in the state of Maine, I then moved to the state of Oregon and took a full bar exam.
Wow.
And practiced there for about a year.
We're gluttons for punishment.
I can see that.
And I did food and wine law as well as business law, and then came down to Florida and have been down here for 5 or 6 years now. Took a full bar exam and have been practicing at Christopher and Weisberg now for a number of years, doing intellectual property law here. I do a lot of the litigation side of things as well as the transactional work.
No, very cool. And you both have quite impressive backgrounds, and that's really why I wanted to have you on the show. And I also think that a lot of people don't really understand kind of what they need to do to kind of file a patent or kind of really even cover themselves when they're looking to kind of, build something or they have something that they think is kind of patented. So, but maybe before we kind of get into that, let's maybe cover exactly kind of what your firm does for clients, and then we'll kind of get into how to go about kind of reaching out to you guys and kind of the whole process. Does that sound good?
Sure. Our firm is an IP boutique, meaning we don't practice any other area of law except, and Alyssa can tell you more about this, but we kind of do some business type law and some contract law and things like that as it is on the periphery of intellectual property.
Sure.
We do pretty much all technology types except some really in-depth pharma and chemistry type things.
Gotcha.
But we do a lot of life science, a lot of devices, medical devices, a lot of consumer products, computer networking, electronics, that kind of thing. And the firm also does litigation. And I'll let Alyssa talk about that.
Okay.
Sure. We do a lot of litigation as it relates to intellectual property, as Catherine said. So the buzzwords that a lot of people will often hear is patent litigation or trademark litigation or trade secret litigation or copyright litigation. And we also deal with litigation with business law and contracts as well, again, because clients oftentimes will come to us and they have litigation as it relates to intellectual property, but then there are things that come along with it that will often involve business disputes and contract disputes. And so we're capable of handling all of those things together. I think that one thing clients often come to us for is helping them harvest and understand their intellectual property. I think a lot of times people hear the buzzwords, thrown around the media, and I can't tell you, and I'm sure Catherine has had this experience as well, how many times a client will call in and say, hey, I have a patent, can you guys help me? And then the client explains it to you, and it ends up being a trademark or a copyright.
Yeah.
And it's just so much because of what you see around in the media and what you read and information that's available, and there's a misconception about a lot of what intellectual property is and in the different categories in which each piece of intellectual property fits.
Okay.
Kevin, I love the title of your podcast because when I first heard that, it kind of reminds me of what we do. Like Alyssa said, I love the phrase also harvesting kind of their idea and helping it grow. And so it is kind of like building the future. Somebody comes in and they have this great idea, and so you start from scratch and you go, where do resources, we're kind of counselors too. Where should resources be allocated, and what's the priority for your business model and for your goals for your business? Are you going to build it and see it all the way to the end? Are you going to try to sell it to someone in a couple of years? Do you have partners? Are you a solo? Is it a product or a service? So it's very interesting to watch some of these companies grow from the initial idea stage into something viable.
Okay. No, yeah, totally. That always kind of fascinated me, and obviously I work kind of on the more of the software side, so I don't really necessarily build something physical, but the thing that I love the most is kind of going from a white screen to a full-blown product, right? And so I totally get that, right? But so I'm kind of curious, and I'm sure a lot of people and a lot of the listeners, they don't even really know where to start. So at what point does it make sense to reach out to somebody like yourselves? And do I need to at what phase in my kind of development do I need to kind of reach out to somebody like you guys?
Sure. I personally think the earlier and the sooner the better.
Absolutely.
Okay.
Because let's say a company is going to pick their name.
Okay.
And maybe they want to use that name and tie it to goods or services and potentially use it as a trademark. Well, what happens if they pick that name and it turns out some other company is using that same name,
sure,
unbeknownst to them, and they put in tons of money and time developing that name, and then lo and behold, it could be 5-10 years down the line, you find out you have an issue. Whereas if you had come to, for example, our office early on, you probably wouldn't have run into that issue. So the sooner the better when people are starting businesses, have ideas, because even if they're not going to come on board right away, we can kind of gear them and tell them where to go and what to do and help guide their choices. And then when it's an appropriate time, if they decide they want to file, for example, a trademark application, or if they want to prepare a patent application, we're then in the best position to help them out, and they've also put themselves in the best position.
Okay. No, that makes a lot of sense. So I'm curious then, so I come to you guys, basically, you kind of brought up something interesting earlier that I found was kind of interesting when you said you basically set them up depending on kind of where I want the company to go. And your comment was like, if I want this, like, let's say like if I want to sell the company to somebody, or maybe I want to license or whatever the deal is, like, do you guys do different things based on depending what I want to do with like my product or what I'm looking to kind of trademark or?
Yeah, that's a really good question. There are some companies where you're saying, okay, first and foremost, like Alyssa said, we always recommend doing at least a preliminary trademark search for your business name, because trademark rights arise with first use. So if somebody starts using it before you, even if it's not in the USPTO database, somebody could be using it. And so the sooner you start using it, the better. So the sooner you can clear it and start using it, the better. If somebody comes in with an idea that might be patentable, the patent system used to be a first to invent system where you kind of could, as long as you didn't disclose your idea, you could work on it for a couple of years maybe and then file. But now it's a first to file. So as long as somebody didn't steal that idea from you, if they independently came up with the idea on their own and filed before you, you're out of luck. So there's really kind of a rush now, and that's in line with most other countries, really. But now you really need to start to develop that and get something filed, at least a provisional application. So Alyssa's right. I mean, the sooner the better is wonderful. But also when you think, if somebody wants to really attract investors or attract potential purchasers, they might want to file something quickly so that they can start talking to these people, start courting these people, start getting prototypers on board. And in that case, the best decision may be to file what's called a provisional application. It's not examined, and it will never issue and mature into an issued patent that's enforceable. But it gets gives you a filing date and gets your foot in the door, and it kind of gives you a little more security to go and talk to potential partners and developers about your idea. Because if you're in a hurry to really start spreading the word about something, you want to have as much protection from the beginning as you can. And also, we found that a lot of investors like to see some kind of IP portfolio, including trademarks, including patent applications. Some investors like to see more of an indication that something is actually patentable. So maybe they want you to expedite examination before the patent office so that they can get an idea faster about whether or not your idea really is patentable and can be used for revenue. So really, depending on the trajectory you think your company is going to take, we can decide whether we're going to act quickly or whether, if you are just kind of moving slowly along and you don't have a lot of money right now, maybe you want to delay some things. Maybe you want to just be able to say patent pending and not have to pay any more fees for the next 3 years. I bring that up because that's currently the trademark office, the patent office averages are about almost 2 years from the date of filing before you get a first office action, a first communication indicating, whether your idea is patentable or not. So there's really a lot of time there, and there's a lot of dead time. Or if you want to pay a pretty hefty couple of $1,000 government fee, you can expedite, which will give you an allowance or a rejection within a year. That's their goal. So there are a lot of different tweaks that we can do to either speed things up or slow things down, or maybe we say it's a great idea. It doesn't mean it's not a good product, but we don't think it's necessarily patentable. So maybe you want to invest your dollars into marketing and branding and market presence instead of patents.
And that's something that we do, is we really take our time with every client that comes into the office and explore their particular business and their particular business plans. And, ultimately, obviously, the decision is up to the client, but we certainly arm the client with the information so that they can make the decision for their business that they think is most appropriate. We will talk with them about, a lot of investors' perceptions about the differences between the provisional application and the utility patent application. I know we're hitting a lot of buzzwords here that many people are not familiar with, but we sit down with our clients and make sure that they have an understanding of each of the different types of patent applications, if patent application is appropriate, that are available, and explore what they can do for the business so that they can move forward most appropriately for their particular business model.
Sure. No, I think that makes a lot of sense. And I think that's the thing that, like, what kind of appealed to me about having you guys on the show is I think a lot of people don't know where to start. And the interesting thing that, that has come out of the conversation that we've been having is you almost basically contact you guys as soon as possible, and then you almost help people through the whole process, right? And you say, no, maybe it is better, like you mentioned, to spend money on marketing and maybe hold off on a patent, or no, we need to do the patent right away. Where I think
Absolutely.
A lot of people don't know that, right? And that's why it's tricky, and that's kind of why I wanted you guys on the show, because like you both said, that in a lot of times, like getting a patent, you need such a history in kind of science and biotechnology and whatever else, right, to give these things. And a lot of times people that are creating these things maybe aren't necessarily, they don't really maybe even know the law or understand the law, or even really have ever really kind of cared about kind of following it, because they've been kind of just chasing their dream or building something, right?
Mm-hmm. Absolutely. A lot of our clients, their head is really in the game in terms of their business, and so they rely on us to know the law. And the law is something that's always changing, constantly evolving. And, what you may know one day may not be true the next day. And so that's why it's so important to rely on an attorney to deal with that issue. And I just wanted to go back for a second.
Sure.
Catherine had talked about the issue with the first to file in the United States.
Okay.
In terms of the patent model. And I think it is so important, when you do have an idea, to get in touch with an attorney about, possibly filing a patent application, because if someone does steal your idea, one, you've laid the groundwork, with the attorney about everything that's been done. There's clear documentation and everything. And two, you just want to get into the patent office possibly as quickly as possible, because you don't want to deal with the ramifications of someone stealing your idea, because, trying to do something with the patent application that was filed with the stolen information, that's probably going to be really expensive and something that, a new business owner doesn't want to deal with and shouldn't have to.
That makes a lot of sense. So I'm curious then, if I filed a patent, am I covered throughout just the United States, North America, the world? Like, how does that kind of work?
Patents are territorial,
Okay.
and so if I file in the U.S. Patent and Trademark Office and I'm granted a patent, I can enforce that against anyone who makes, uses, sells, imports something or does something that falls within the scope of my claims. And again, I know we are using some buzzwords, and but really it's the claims, and we can get into that if you want, or if not. But that's kind of the touchstone. So I can enforce that all over the United States. If I also want to file abroad, if I want to be able to enforce my patent abroad, then I have to go some other routes. And there are some different ways you can file internationally. There is no such thing as an international patent right now, but there is an international filing system that then allows you to delay the time you have to file in other countries. It's called the Patent Cooperation Treaty application. But for example, say I know I want protection in Germany and France. I can either file directly in the German Patent Office and file directly in the French Patent Office, or I can file what's called a European patent application in the European Patent Office. So if I go that route, the patent is examined at the EPO level, the European Patent Office, and then if they say that it's allowable, then I can pay a couple of extra fees and have it what they call validated in Germany and France. If I file directly in Germany and directly in France, you're being examined by some different patent offices, so your results might be different. But if there's only one or two countries of interest and you want to go right there, and then you know that's all you're going to do, then maybe direct filing is your answer, or you can file the international application. But if you want to enforce it anywhere outside the United States, you do have to file. You have to file abroad. And one interesting caveat, Alyssa said that it's important to talk to people who know the law, and that's true because there are so many pitfalls for the unwary. For example, if I develop a product and I start talking about it and posting it on Kickstarter, and I make a prototype and I'm showing all my friends, in the United States, I have 1 year from the date of that first public disclosure to file a patent application. Otherwise, I'm barred from obtaining a patent at all.
Oh.
So you have a 1 year grace period. So that's why time is really important. But even more than that, the U.S. is one of the few countries that has a grace period. So if I think I want to file abroad and have protection outside the United States, the minute I disclose, I'm barred. So they have a no grace period policy. Most other countries. So it's for practicality, we always say file something before you disclose to anyone, even in the United States.
And that's often a pitfall for new inventors and new startup companies, because they're trying to figure out how to generate revenue. They're talking to people. They're, feeling out the landscape of everything that's going on, and then lo and behold, they find out they can't get a patent.
Sure.
Because they've made a public disclosure.
It happens a lot, actually. Universities, they have their tech transfer offices and they file patent applications routinely, but they have to be very diligent about getting all the information from the professors, from the researchers, from the inventors, because scientists love to publish. That's their goal, is to publish in journals and present at conferences. And if they do that before the tech transfer office is able to or gets around to telling their outside law firm to file a patent application, then you could be in trouble.
Right, and sometimes when that does happen to clients, if they come to us after the fact, we try to problem solve with them and see if there is another way to protect whatever their idea is.
Okay, interesting. So I know we kind of covered a little bit of kind of what happened, like who you guys kind of service, and we're kind of talking about kind of protecting yourself. But what do you guys kind of see, or is there kind of a standard kind of way of kind of, to generalize, I guess, if somebody comes to you with like a hardware product or say a software product, is it different? Is it the same? Or does it really depend on what their product is, whether it's hardware or software or a combo of both?
It'll depend, because there have been so many changes in the law lately about what's patentable subject matter.
Okay.
And especially one of the hardest hit industries really has been the software industry. It's becoming increasingly difficult to patent software alone. And some will say to the point where, just don't even try. But if you have software that is run on a computer and causes an effect somewhere down the line, like maybe it's some kind of automated machinery, or maybe robotics control or something like that, where it's not just an app running on your phone or just software that's like, word processing software or something like that. If it actually has a mechanical effect or there's some special type of analysis, then it may be more likely to be considered patentable subject matter.
And then depending on the particular software product that the person is interested in, if patents, as Catherine was saying, are going to be more challenging, or the person financially can't undertake trying to apply for a patent, again, there may be other areas of intellectual property that could be used to try and protect that software product, whatever it may be. Obviously, we're talking very generally about a large variety of different software possibilities.
but
oh, sorry, go ahead.
No, I was just going to say, but I think that's kind of like the point that I kind of wanted you guys to make is like, the sooner you guys, or the sooner like somebody comes and talks to like an attorney, the better off they're going to be, right? Because you could really get burnt down the road, or you think you have something that you can patent or whatever. But you may or may not be able to, but there might be other ways that you could protect yourself, right? Or your product or service.
Yes, certainly coming sooner rather than later is a great idea. It's always the, penny wise, pound foolish, because people will come in or they'll delay coming in, and then they get, slapped with a lawsuit, or they get the cease and desist letter, and guess what? By that time, it's pretty late down the road, and certainly we do what we can to rectify the situation, but it's often a lot more expensive, a lot more time intensive, and oftentimes it can be very damaging to the business.
Sure. So is there kind of, and I get this is just kind of a general kind of question, is there kind of a set amount that somebody should kind of set aside for kind of getting things rolling, like as a startup kind of legal fees? Like, is it a couple thousand? Is it 10,000? Is there kind of a general number that you're kind of should start out with? And when you come to like a firm like you guys and say, kind of help me set up my company and see how I can protect my kind of property?
Yeah, we will. The quotes that we'll give now are very much in line with the national averages. If you go to a very large law firm, especially general practice law firm, you may be looking at obviously more expensive, or if you go with a solo attorney, or maybe less expensive. But in general, to prepare and file a utility, it's like your regular patent application that is examined, is anywhere between $7,500 and $10,000, depending on the technology, because it takes us about 20 hours to prepare, to go back and forth with the client, to really understand the invention, to work with the draftsman who prepares the drawings that are acceptable to the USPTO, and then going through the actual process of uploading all the documents and making the filing with the USPTO. But then there's also other costs that are involved, and it's really difficult to give a soup to nuts kind of estimate, because you never know. And you just never know, because so much examination is subjective, and it's true for trademarks as well. Trademarks are obviously less expensive than patents, but you get an examiner, and they're all trained the same way, but they look at things differently. So one examiner may have a completely different opinion than another. So it is kind of, a lot of it's luck of the draw. I mean, how willing the examiner is to work with you, to talk with you, to try to understand the invention. But you're looking at least one, most likely two additional office actions, we call it. So those are our opportunities to go back and forth and negotiate with the examiner to try to see if we can come to a mutually agreed scope of the claims, something that we agree is patentable. And each of those is another couple of $1,000s, and then if it's allowed, you have to pay an issue fee, and then there's maintenance fees over the life of the patent. So it can be extremely expensive, or if it's one of those rare unicorn inventions that is completely different and non-obvious than anything else that's out there, maybe it goes right through first office action allowed. That's very rare, but sometimes it happens. So if you want to budget for a full patent, I would say budget at least 20. It could be less, it could be more, but keep in mind that most of that is going to be spread over, other than your initial filing, that's spread over very many years.
Sure.
And putting my litigator hat on,
Sure.
it's very important that, if you file the patent application and you do get an office action back, that's actually in a lot of ways helpful to your application, and ultimately if you get an issued patent, because what the United States Patent and Trademark Office is doing, or the examiner is doing, is looking at that application saying,
absolutely,
is there something in this application that's potentially problematic? Is there prior art that's going to be problematic that I can find? And so it's really, vetting out the application and giving you a second bite at the apple, and seeing, possible issues that could arise with the patent application, and also if the patent actually issues. Of course, there's no guarantee when you get an issued patent that it's going to stand up in court.
Sure. So this might be kind of a stupid question, but is there kind of a minimum and a maximum amount that you can, like, you get your patent, but is it like 5 years, 10 years, 20 years? Does it really depend on what your technology is? Or like, how does that kind of work?
There are different, they call art units in the USPTO, and depending on the technology area of your invention, they're assigned to examiners in particular art units. So, all the cardiac ablation catheters are put into one art unit, and all the the food containers are put in another art unit. So I think some art units definitely have a faster track record than others. Maybe they get fewer applications. Those applications are less complicated, so they're easier to examine. So really there is no there's no kind of good estimate that's across all art units, but the average really is about 3 years.
Oh, wow.
About 3 years, and you wait almost 2 years for that first office action, and then it kind of goes a little more quickly. But what happens is you file the application, and then it's kind of in USPTO purgatory for a little bit until it's eventually assigned to an examiner, and then it goes on that examiner's docket, and they get to it when they get to it. So if it's a particularly busy art unit, maybe they have 50 applications ahead of you, and it takes them another year to get to it.
And I think that that's something that's really difficult oftentimes for particularly startup companies, because they really just want to get to the end of the line of the issued patent.
Sure.
And it takes all of these, years from the date that you file the application to the time in which you actually get an issued patent. And so, there's that uncertainty as to whether or not they're actually going to get an issued patent. Maybe some investors are waiting for the patent to issue. And so again, going back to what Catherine had said earlier, although again, it's more money up front, it could be a couple $1,000s to file the patent application on an expedited basis. What if you have an investor that's willing to put in $20,000 when you get the issued patent? It may be worthwhile for that particular inventor to put in the extra money on the front end, because it's really going to help on the back end with their business.
No, that's really interesting. So I'm curious then, what happens, because if it takes me, say, a year or two to get my patent and I get it for 3 years, what happens if I get acquired before, or when I'm kind of in the midst of getting a patent? How does that work?
Well, in that case, if the company is acquired, then the purchasing company no doubt will want the intellectual property rights. So in that case, it can be assigned to the new company.
Okay.
So when you file an application in the United States, really any country, you identify the inventors.
Okay.
And then you can identify the applicant. And with recent law changes now, the U.S. allows non-inventor applicants, whereas they didn't before. So that kind of makes it a little easier, because the inventors may or may not be the owners of the patent. They may have assigned their rights to their employer or to a different company, and then that employer or that company, the owner now gets to control prosecution of that patent. So if the patent is acquired by someone else, it's a fairly simple assignment to them, and then we record it with the patent office, and they're the new owners.
Got you. Okay, so I get my patent. I have, say, hypothetically, it's for 3 years. What happens after the 3 years? Can I apply to get it extended? And when do I kind of start that process?
Well, it takes 3 years for the patent to issue, meaning you're an application until an examiner says, okay, we have something allowable, and then it issues as an enforceable patent. And so once it issues, you can assert that patent against potential infringers.
Okay.
The patent term you're given is 20 years from the date of filing.
Oh, okay.
Correct.
I got you. Okay, that makes sense.
Yeah, and so there are different ways that term can be extended by a little bit, a couple 100 days, 1,000 days, something like that. It's called the patent term extension. So if the patent office drags their feet and delays, they'll kind of reward you, give that back to you a little bit on the back end. But yeah, so you have 20 years, and that's the public policy behind the patent system, because companies invest so much money into research and development and coming up with these products and services, and maybe they wouldn't be quite as incentivized to do that if they didn't have the possibility of recouping a good portion or more of that cost in licensing and sales and all the things that go along with having IP in a product. So so you're given a 20-year monopoly by the government to do that. But in exchange for that, you have to describe your invention in enough detail that at the end of that patent term, it's public domain. And I think a lot of people are very hard on the patent system because nobody should own certain things. But it's really a very limited monopoly. And at the end of that, the public is enriched basically by all the work and investment that the inventors have put into it.
Right, and I think you often see that played out in the media as it relates to drugs that are being created by different drug companies. And I know people often get very upset because the drug companies get this monopoly, as Catherine said, for those 20 years from the date of the filing. But at the same time, they are disclosing the nuances to the particular invention, so that enables others to then take whatever the invention was and try to make it better and try to make something new, useful, out of what's already existing. And that's why we have such incredible ingenuity and innovation in so many areas, because we do have this information that's publicly available and readily disseminated.
Okay. No, that makes a lot of sense. But once it goes public domain, nobody else can basically file a patent again for that so they can capitalize for another 20 years, or it's just public domain. You can't do anything with it.
Yes, absolutely.
Right.
Okay.
And you can never, once it's in the public domain for those 20 years, you can never try to file a patent application again for that same invention. That's it. You get the 20 years and then you're done.
Okay. And so if you have something that you think is similar to something that's already been patented and maybe public domain, you have to spend a huge amount of time obviously trying to prove how you're significantly different.
Well, not necessarily. And again, I think that goes to coming into a patent attorney very early on in the process, because there may be some, minor tweak that you've made to a particular creation or invention that you've made that differentiates it from, what's already out there in the prior art. And so that's what we often do for clients, is we can craft your patent application in such a way that it highlights whatever that nuanced difference might be from what's already out there in the prior art.
Kevin, I like your question. It reminds me of an example that I was talking to some people about the other day. So, when you have a patent, you don't necessarily own the world, and sure. I can enforce this against anybody. And I always thought this dilemma was so fascinating. Say somebody has invented the chair and they have a patent on the chair.
Sure.
Somebody else comes along and they say, I can improve that, and they invent a chair with wheels. Then their chair with wheels is different enough that the patent office says, okay, you can have your own patent. So now we have two people, one with a patent on the chair and one with a patent on the chair with wheels. So the person with the chair with wheels has a patent because they have a new invention, but they still can't make the chair with wheels because they need permission from the owner of the patent with the chair.
Got you. Okay.
So that's a whole other part of the industry too that we also help clients navigate is cross licensing and exclusive licenses and partnerships and things like that, where just because somebody has a patent on something that may be similar to yours doesn't mean that they're the enemy. It may open doors for new opportunities. Maybe you go into business together or give each other exclusive licenses and really kind of piggyback on each other's market presence.
No, I think that's actually interesting, and you brought up something that's really interesting. So how do you go about, so like the chair example, how do I go about contacting the guy that owns the chair and kind of say I really need to license your technology so I can build my thing, right? Mm-hmm. How do you go about doing that?
Yeah, on the face of the patent, it'll say it'll say who the inventors are, and in most cases there will be, a lot of cases there is an assignee, like a company assignee.
Okay.
So you can certainly find on public records the contact for the company. If it's an individual, I'm not sure how much information they provide, but Alyssa, do you know of a good way to contact?
Oftentimes, you can just go onto the internet and find the person after you've located the information on patent, I would always caution people in contacting them and the timing of contacting the owner, in our example, of the chair.
Sure.
Because there may be certain things that, you may not want to disclose everything all at once, in your first communication with the other inventor. So you definitely want to have a well-thought-out plan before you reach out to that other owner of the invention.
Another reason to talk to an attorney.
No, but that's kind of why, where I was kind of going with this, right? Is because if you need somebody else's patent, you kind of need to cover yourself before you go to them, because if you don't patent it, they could basically just say, well, I'll just add that to my thing.
Yeah, this is where the chess game of patent comes in. If I have an application that's still pending, say, it hasn't been allowed yet, but it's being examined.
Sure.
At any time, I can file a related application that has the same, I've disclosed the same thing, so I'm not changing that. I'm just trying to redefine what I want to carve out as my claims. And so the claims are really the metes and bounds of what you're allowed to enforce. So say I want to claim a little more broadly, or say I want to claim a different feature of my invention. I can do that. I can also file what's called a continuation in part, and that is where you can add additional subject matter. You may not get the benefit of the original filing date, and that's kind of a little more nuanced, but you are allowed to add a certain amount of subject matter under certain circumstances. So a new embodiment, a new feature. However, if you didn't invent it, then you're not the first inventor. So in order to, you not only have to be the first to file, but you also have to be the first, really the first inventor. You can't you can't steal it from someone, in another word. So if I see that a competitor is doing something and I hadn't thought of that, I to prevent an allegation of fraud, I can't then say, oh, I'm going to claim that in my patent application. I mean, you have some opportunity to add new stuff, but it still doesn't facilitate. You know what I'm saying?
Yeah, I got
taking someone else's idea.
Yeah,
and I think that goes to the heart of the patent drafting, as Catherine was saying, are the claims. And drafting of claims is certainly an art, and something that, again, is so important, because that is what your invention is, and that's what you're going to be entitled to enforce, and that's the basis of whatever you filed for 20 years. So if you get an issued patent, so you want to make sure that you have well-drafted, well-thought-out claims when you go forward with filing your application.
And someone like Alyssa, who does do patent litigation, is in a really, really good position to draft strong claims, because she sees it from both ends. She sees, the havoc that weak, poorly written claims can do in the courtroom, and she sees, how well-crafted claims can stand up.
And I think that's why, our office is so interesting, because we do have what's called the prosecution side, so the drafting of the patent applications, the drafting of the trademark applications, the copyright applications, and all the related intellectual property. But we also see the litigation side, so we see where the problems arise and where things have gone wrong. And so it's always interesting, because we all work together as a team to put together the strongest applications for our client. And then the same is true when we're litigating. We have the same kinds of resources, because we're so actively involved in all facets of intellectual property.
No, that makes a lot of sense. And I think that this whole space is kind of fascinating to me, partly because I don't know tons about it, but it's a little bit daunting when you kind of first come into this, right?
Oh, yeah.
Absolutely.
and there's so many ways you can go, and there's so many ways to, based on kind of what you have and what's already out there. And I know, some of my questions have been kind of a bit general, but I think...
No, that's important.
Yeah,
Absolutely.
because it's kind of people need a starting place, right? And I think a lot of people don't even know where to start. And I think just kind of getting advice from a lawyer as soon as possible on kind of whatever you have, and getting recommendations, and the fact that you guys kind of do both sides of the fence is super useful for your clients.
And I would tell people too not to be intimidated by going and talking to an attorney, because there are a lot of firms, including ourselves, who will, do a free initial consultation, come in and talk to us, and let's see if there's an opportunity to work together. And they pick up. There's a lot of people that we meet that come in and talk to us that, don't move forward for another couple of years.
Sure.
But it's that free kind of just the initial getting your feet in the water and just using us as a sounding board and trying to see if maybe your idea is viable.
Yeah, no, I think that makes a lot of sense. We're kind of coming to the end of the show, so maybe do you guys want to kind of close the show with mentioning again where people can find you guys online and any other kind of social media links you guys want to mention?
Sure. Our website is www.cwiplaw.com. It stands for Christopher and Weisberg Intellectual Property Law.com. We're all on there, and we do have a Facebook page as well, Christopher and Weisberg. I believe we're on Instagram as well under Christopher_Weisberg.
You can also, if you Google either of our names, will come up as well if you can't get onto the website for whatever reason. And we would also encourage you, if you'd like to follow us on Facebook or through Instagram or any other social media, feel free. We'd love to have you join us.
Yeah, and do your due diligence. Check out our attorney profiles and any law firm you consider. Always look at their credentials and see if you like their style.
And I think something that's very important about intellectual property, it is very much a niche area of the law, and there are so many technicalities and differences from other areas of the law. I know Catherine and I have spoken with many attorneys who don't practice in intellectual property law and have no idea of the difference between a patent and a copyright and a trademark. So let alone other people who have never ever really been introduced to any of these concepts like the lawyers had been in law school. It's a very daunting area that scares people, but I think a lot of times once you've had an opportunity to sit down with an attorney and go through, what's available and your particular situation and circumstance, it makes the person feel a lot more comfortable. And, knowledge is power. And once you get that knowledge and have that information, you can go forward and create a much stronger business plan and a much stronger plan going forward where you're going to get more investors, more likely, and you're putting yourself in a win-win situation.
Sure. No, I think that's actually really good advice and makes a lot of sense. But ladies, I really appreciate you taking the time out of your busy schedule to be on the show.
Thank you so much.
Yes, thank you.
Yeah, awesome. All right, well, you guys have a good rest of your day, and we'll talk soon.
Bye.
Okay.
Bye.
Yeah, thanks. Bye.
Thanks for listening. The music for the show is done by Electric Mantra. You can check them out at electricmantra.com and keep building the future.